The Senate will please come to order. We do not have a devotional this Friday morning, so we will take a moment of silence. Thank you. Are there any announcements this morning? Seeing none, we will move to Senate bills for introduction. I believe we do have a number again today. S-255, an act relating to regulating consumer fees for communications equipment, introduced by Senators Pearson, Lyons, and Sirotkin. Please listen to the first reading of S-255.
S-255, an act relating to regulating consumer fees for communications equipment.
You've heard the first reading, and the bill is referred to the Committee on Finance. S-256, an act relating to applying the discovery rule to civil actions relating to warranty claims in common interest communities. Please listen to the first reading of S-256, which was introduced by Senators Sirotkin, Balint, and Benning.
S-256, an act relating to applying the discovery rule to civil actions relating to warranty claims in common interest communities.
You've heard the first reading, and the bill is referred to the Committee on Judiciary. S-257, an act relating to limitations on hospital liens, introduced by Senators Pearson, Brock, Clarkson, and Hooker. Please listen to the first reading of S-257.
S-257, an act relating to limitations on hospital liens.
You've heard the first reading, and the bill is referred to the Committee on Judiciary. S-258, an act relating to amending the required agricultural practices in order to address climate resiliency, introduced by Senators Pearson and Polina. Please listen to the first reading of S-258.
S-258, an act relating to amending the required agricultural practices in order to address climate resiliency.
You've heard the first reading, and the bill is referred to the Committee on Agriculture. S-259, an act relating to the reorganization, enhancement, and enforcement of animal welfare requirements in the state, introduced by Senator Collimore. Please listen to the first reading of S-259.
S-259, an act relating to the reorganization, enhancement, and enforcement of animal welfare requirements in the state.
You've heard the first reading, and the bill is referred to the Committee on Agriculture. S-260, an act relating to eliminating certain exemptions from the minimum wage, introduced by Senator Pearson. Please listen to the first reading of S-260.
S-260, an act relating to eliminating certain exemptions from the minimum wage.
You've heard the first reading, and the bill is referred to the Committee on Economic Development, Housing, and General Affairs. S-261, an act relating to municipal retention of property tax collections, introduced by Senator Parent. Please listen to the first reading of S-261.
S-261, an act relating to municipal retention of property tax collections.
You've heard the first reading, and the bill is referred to the Committee on Finance. S-262, an act related to creating a right to repair personal electronic devices, introduced by Senators Pearson, Clarkson, Hardy, Hooker, and Sirotkin. Please listen to the first reading of S-262.
S-262, an act relating to creating a right to repair personal electronic devices.
You've heard the first reading, and the bill is referred to the Committee on Economic Development, Housing, and General Affairs. And finally, S-263, an act relating to supporting economic development, introduced by Senators Clarkson and Ballot. Please listen to the first reading of S-263.
S-263, an act relating to supporting economic development.
You've heard the first reading, and the bill is referred to the Committee on Economic Development, Housing, and General Affairs. That concludes, I believe, all of our bill introductions for today. We shall now move to the orders of the day. We have on the calendar for action S-224, introduced on January 11th, 2022. It was referred to the Committee on Judiciary, which reports it has considered the bill and recommends that the bill ought to pass. Please listen to the second reading of S-224, an act relating to juvenile proceedings.
S-224, an act relating to juvenile proceedings.
The senator from Bennington, the chair of the Committee on Judiciary, is recognized for an explanation of S-224.
Thank you, Madam President. It's a pleasure to be here with this bill. The genesis of the bill is really when the governor vetoed S-107, he mentioned several concerns about the Raise the Age effort in 2018. To remind ourselves, in 2018, the legislature decided to pass legislation that raised the age for juveniles from its current 16 and 17-year-old to 18 and eventually 19-year-olds. The 18-year-old raised the age took place on July 1st, 2020, and the raising the age to 19 was scheduled to take place on July 1, 2022, which is just a few months from now. I think it's helpful and we also passed several pieces of legislation improving the youthful offender process for those under 22. The reason the legislature did this, and we were the first in the nation to actually raise the age beyond 17, is because of brain science and developmental research that found that youth, and if we look back to the time when we were 18 or 19, youth are much more volatile in emotionally charged settings. They're susceptible to peer and other outside influences. They're risk takers, they're impulsive, and frankly, less future-oriented. The above factors are exaggerated in youth who have experienced trauma and brain injury. We know that high rates of trauma for court-involved youth, about 90% of court-involved youth have had at least one traumatic event. All youth adapt, but the question is not if, but how they adapt. Flight, fear, and freeze responses, which are primitive, are very often the way they deal with emotional problems. These traumas shape and delay development of these youth. The other factor that we know, and looking at a 9-year recidivism rate amongst 18 to 24-year-olds, found that within 9 years, 90% recidivate or get rearrested. If you think about those numbers, our adult system isn't very effective with 18, 19, 20, 21-year-olds. Just isn't. And mixing that population in jails doesn't help. In nationally, and there's no reason to believe it's not as true in Vermont, the Black males are in the 18 to 24-year-old comprise 42% of all emerging adults admitted to state and federal prisons in the United States in 2016. Repeat that. 18 to 23-year-olds comprise 42% of all emerging adults. Racial and ethnic disparities are highest for younger cohorts, ages 18 to 19. Black males age 18 to 19 are 11.8 times more likely than their white peers to be incarcerated. So what we found through science and what we found through own experiences led us to raise the age. Unfortunately, when we raised the age, we didn't expect a pandemic. And we also needed to learn a few things, and with any laws that are as major as this, there will be time to review and to look upon them. So S-224 makes several changes to both the youthful offender statutes as well as the raise the age. And I'm going to go through it section by section, but the changes involve several different areas of the law. The first sections 1 and 2 propose a 1-year pause on the raise the age issue initiative that would move the 19-year-olds from July 1, 2022 to July 1, 2023. Your committee heard a lot of testimony on it, and while the administration wanted benchmarks before the raise the age, the other witnesses and everyone else agreed, and the administration eventually, I'm talking now DCF, agreed that a 1-year pause would be desirable. Prior to this initiative, a young person who committed a crime could only be charged as a juvenile in the family division if the youth committed the crime at age 17 or younger. I want to note that these rules do not apply to more serious offenses known as the Big 12, which still must begin in the criminal division. Under the second step of raise the age, which is scheduled to go into effect, as I said, on 22nd of July 1, 2022, it would have been anyone 19 or under, and that moves to 2023. The committee also heard testimony that some clarifications we need to ensure the victims of juvenile offenses can obtain the compensation and restitution they are entitled to under current law. Sections 3 and 4 of the bill address this issue. Section 3 provides the victim compensation program with the information it needs to verify reimbursements requested by the victim. It allows the program to obtain a copy of the law enforcement officer's affidavit of probable cause, so long as all information identifying the youth or delinquent child is redacted. When a juvenile is unable to pay restitution, Section 4 requires the court to establish a payment schedule based on the juvenile's current and reasonably foreseeable future ability to pay. The amount of restitution cannot exceed what the juvenile can pay. Section 4 also clarifies that sealing of juvenile records does not affect the authority that the restitution has under current law to enforce restitution orders in court. Procedures for victims in juvenile proceedings are also addressed in sections 5 through 12 of the bill. Sections 5 and 6 are technical in nature and strike out outdated language that suggests victims do not have notification rights in delinquency proceedings, and added language to make clear that these rights are governed by the relevant juvenile statutes. Section 7 involves the ability of a crime victim to discuss their personal experiences as victims of a juvenile offense. Under current law, juvenile proceedings are confidential, and it's unlawful to publicize them without the consent of the child and the child's parents or guardian. The new language in Section 7, which is consensus language agreed to by victims, prosecutors, the Defender General, and others, in court, makes clear the victims remain free to discuss underlying facts of the alleged offense that result in harm to the victim, so long as the victim does not discuss what occurs during the court proceeding or information learned through the court proceedings. The victim can discuss the underlying facts of the case that caused them harm without violating juvenile confidential requirements. Section 8 of the bill requires law enforcement officers to give the same information to victims in juvenile proceedings that they are already required to provide to victims in adult criminal proceedings. This section simply repeats the same language that already exists for the adult criminal cases. Section 9 permits the victim in a juvenile or youthful offender proceeding to be accompanied by a victim's advocate at any court proceeding where the victim is ordered to attend or has the right to attend. Sections 10, 11, and 12 make rights of victims consistent in juvenile and youthful offender proceedings. Because these sections of law have been amended at different times over the years, several inconsistencies have developed unintentionally. These sections remedy those problems several ways. First, victims in each type of proceeding must be notified by the state's attorney about the child or youth's conditions of release unless a court orders provides otherwise. Second, the victim must be notified whenever the child or youth is released from a secure residential facility. Current law only provides such notice when the victim requests it. Third, the existing right of a victim to attend and express their views in a youthful offender proceeding is repeated for victims in juvenile proceedings involving listed crimes, since both proceedings involve very serious offenses. Lastly, the language I explained earlier, which permits victims to discuss the underlying facts of their cases, as long as they do not discuss the court proceedings, is repeated for the youthful offender proceedings, just as was proposed for juvenile proceedings. Section 13 addresses the existing statutory requirement that the court find public safety will be protected before granting a motion for treatment as a youthful offender. The statute does not describe what considerations should go into the public safety determination. So section 13, current statute doesn't provide that information. So section 13 adds a detailed list of criteria for the court to consider. That criteria is based on Vermont Supreme Court decision in a case called In Re BB from 2019. So the court should be familiar with them. Section 14 also concerns the public safety issue, this time in the context of delinquency proceedings. Current law permits a state's attorney to file a motion asking the court to transfer to the criminal division a felony case against a child that would otherwise be a delinquency proceeding in family division. When deciding whether to grant the state's attorney's motion to transfer the case from family division to criminal, the court is required to consider public safety. The statute does include some criteria for public safety determination, and section 14 expands the list so it's consistent with the criteria that we added for youthful offender determinations in section 13. Section 15 amends the existing statute, which requires a youth to complete a risk and need screening before commencement of youthful offender proceeding. Section 15 makes clear that the court notifies the youth that participation in the need screening is required, and the failure to do so may result in a denial of the youthful offender treatment. Section 16 permits the court to order a psychosexual evaluation in certain types of cases to help determine appropriate conditions of probation in a juvenile case plan. The list of offenses which the evaluation may be ordered is the same list which the court may order for adults when the Department of Corrections is conducting a pre-sentence investigation. Section 17 requires DCF to report to the Senate and House Judiciary and Institutions Committees by December 1st, 2022 on the availability of secure placements and transitional housing for 18 and 19-year-olds subject to juvenile and youthful offender proceedings. The report also must include a progress report on the requirement that the Raise the Age initiative be implemented in 2023. Section 18 provides that the bill takes effect on passage. Madam President, the committee was unanimous in its support for this bill. And as I mentioned earlier, the stakeholders, including the Defender General, the Juvenile Defender, the state's attorneys, the court, and DCF, and others were all in support of S-224. I might add that one of the problems that we face right now during this time of a pandemic and others is that we no longer have secure residential facility in the state for either juveniles or youthful offenders. And I know that many of us have been receiving emails and letters from either our local hospitals, from caseworkers, from others about the serious nature of some of this behavior. And I think it's really important that we recognize that we have a significant problem that needs to be resolved in the interim, no matter what happens with the replacement for Woodside that was planned for Newberry in it's at least 6 months to a year off. So hopefully all of the committees in the Senate with jurisdiction over these matters, from health and welfare, judiciary, appropriations, institutions, will continue a concerted effort to make sure that there are placements available for these youth. Many of the places that were designed to replace the Woodside temporarily have been hit very hard by COVID. And we heard, at least in Bennington, I heard last Monday from many of my constituents of problems at the hospital with nurses, security guards, and others being assaulted by youth who are housed there because of mental health issues. And once those mental health issues are cleared, there is no place for that person. And they end up staying in the emergency room for a long period, some up to 17 days. And it's not healthy for either the children or for our hospitals and others. And part of this is that many of the programs that house our delinquent and unmanageable youth have been hit hard by COVID. And I know that the Brattleboro retreat was closed to new admissions due to COVID at least this week. And so this just compounds the problem. And I think it's imperative that we all work on this issue and keep it fresh in our minds. Thank you, Madam President, and the Senate Judiciary Committee would appreciate the vote of the Senate.
Thank you, Senator. The question now is, shall the bill be read the third time? Are you ready for the question? The senator from Addison is recognized.
Thank you, Madam President. May I inquire of the reporter of the bill?
You may.
Thank you, Madam President. I just want to underscore the clarification that this would be a delay of 1 year for the youthful offender, and then after that, it would go into effect. And could you just clarify the reasoning for that delay?
It's actually the raise the age from 17 to 18 as the limit went into effect July 1, 2020. And originally we provided a 2-year period for the department and others to get up to speed and move towards 19-year-olds. It's the 19-year-old group that would not go into effect until July 1, 2023 instead of 2022.
Okay, thank you. And then I do have a question, and this is actually a question more on current law. It's not a section that's changing, but I wanted a clarification on the section. It's section 14, transfer from family division of the Superior Court. And it has you mentioned that the youthful offender law does not apply to the Big Five. Is that correct? Big 12. Okay, so I think it's.
I mean, unless it can. it can under certain circumstances. It's up to the state's attorney.
Right. So that's actually, so I think section 14 is listing the Big 12. Thank you for clarifying that number. And then could you explain to me the ways in which it could apply to the Big 12? What happens to make that happen?
The state's attorney would have to move to allow, as I understand it, to allow to have.
And okay.
I'll check to confirm that, but I believe it's the state's attorney that has to move. The other offenses that can be treated as a youthful offender, the defense can move, but when it's a serious offense, it has to be.
So could you, when you're asking for clarification, could you ask, could a defense attorney petition to have one of the Big 12?
No, I don't believe so.
Okay. If you could get clarification before third reading, just to underscore this point, I've had recently been contacted by a constituent about this point. And I just want to make sure before we vote on third reading or we could have a conversation. But if you could get clarification before third reading, I would appreciate it, Madam President. Thank you.
I want to make sure I understand the question, Madam President.
Okay, I can
repeat. The question is, can the defense attorney in a Big 12 case move to have a youthful offender, have the person treated as a youthful offender?
Yes, can a defense attorney move to have a defendant treated as a youthful offender? And does that motion require the prosecutor or the state's attorney to approve it, or how does it come about? So what is the process for someone who's been charged with a Big 12 offense to move from family court to the Superior Court? And just wanting to make sure that there are sufficient protections for victims of a Big 12.
Yep. Okay.
Thank you, Madam President.
The question is, shall the bill be read the third time? Are you ready for the question? The senator from Washington, Senator Perchlik, is recognized.
Madam President, may I inquire of the presenter of the bill?
You may.
Thank you, Madam President. Last year, the governor vetoed S-107, and some of us were a little confused by his veto message because he referred to the raise the age. And it's not really a question directly to the bill, but I wonder if the presenter of the bill would know if the things that are in this bill address some of the concerns that the governor had in his veto of S-107. And we can also just hear about that before third reading.
I believe that everything in this bill addresses the governor's concerns about both youthful offender and raise the age. However, it does not address his concerns about the public record portion. And I would yield to the senator from Wyndham, who's a member of both the Senate Judiciary Committee and chair of the Senate Government Operations Committee for more clarification on that. We did not deal with the public record aspect of that.
Okay. Thank you, Madam.
Thank you. Does the senator from Wyndham wish to be recognized?
Thank you, Madam President. Yes, I will just say that the veto message did not really address the 107 as such. It addressed the raise the age, but there is a bill right now, S-175, that is essentially the same as S-106 with some modifications to make sure that it tracks the raise the age, this bill.
Thank you, Senator. Are you ready for the question? Kindly unmute. The question is, shall the bill be read the third time? All those in favor, please say aye.
Aye. Aye.
Those opposed, nay.
No.
The ayes appear to have it. The ayes do have it, and you've ordered third reading of S-224. I don't believe there's any other business today. The senator from Wyndham is recognized.
Thank you, Madam President. Pending announcements, I move that the Senate stand in adjournment until 9:30 Tuesday, January 18th.
The senator from Wyndham has moved that subject to any announcements, the Senate do stand in adjournment until Tuesday, January 18th at 9:30 a.m. Are there any announcements? The senator from Caledonia, Senator Benning, is recognized.
Thank you, Madam President. The Senate Institutions Committee will be meeting at 1 o'clock.
Thank you. The senator from Washington is recognized.
There it goes. Thank you, Madam President. My button wasn't working. Senate Finance will meet at 1:45 today. Our first witness had to cancel, so we're rescheduling, but it will be 1:45.
Thank you. The senator from Bennington, Senator Campion, is recognized.
Thank you, Madam President. Senate Education will meet at 1:30.
Thank you. The senator from Wyndham is recognized.
Thank you, Madam President. Senate Government Operations will meet at 1 o'clock.
Thank you. Are there any additional announcements? The senator from Wyndham has moved that the Senate do adjourn or stand in adjournment until Tuesday, January 18th at 9:30 a.m. Are you ready for the question? All those in favor, please say aye.
Aye.
Aye. Those opposed, nay. The ayes have it, and the Senate stands adjourned.